This is case number 13-8320, People versus Robert Bashara. Today is the day for a post-conviction.
Cheers for the record.
Good morning, Your Honor. Lisa Lindsay on behalf of the people of the state of Michigan.
Hey, good morning, Your Honor. John Tado for the people. Ronald Ambrose appearing on behalf of Robert Bashara.
Okay, you may be seated. The court had an opportunity to have a sidebar on this matter, and what the court is going to do is, when we were here, when we last heard, Ms. Lindsay did cross-examination and she concluded it. How are you doing, Mr. Bashara?
I'm okay.
You
Thank
sure?
No, well, I'm not great. I'm okay.
All right, very good. All right. Anyway, so what I'm going to do is I'm going to allow Mr. Ambrose to do redirect. However, the court rules do allow the court to limit the scope of redirect, and the court is going to give an hour. I do think that that's sufficient. We have covered a lot. Direct examination has been extensive, as well as cross-examination. And so therefore, Mr. Bashara, are you prepared to take this? You know, you don't look too good today.
I'm okay.
You sure?
I haven't taken my medication for 4 days, and they gave it to me this morning, 2 hours after I ate. Deputy Vitti was nice enough to provide me a sandwich and a juice just now, so I'll be okay.
You sure?
I am absolutely, this is very important.
I know, but I'm just saying, I don't want you, if you're not able, because you look like you're a little tired. Huh? You
no,
good?
I'm fine.
You sure?
I was a little lightheaded about 20 minutes ago, but I had a little something to eat. I'm fine, thank you.
Okay, but you're not lightheaded anymore?
I'm better. I'm going to proceed, Your Honor. If I have a problem, I'll let you know.
When did you take the medicine?
No, I'm fine.
Did you hear what I said? I said, when did you take the medicine?
This morning, at 8:30 this morning, right before they came to bring me up.
Okay, so then when did you get lightheaded?
About half and 20 minutes ago in my cell in here in the holding. And then when he came, I asked him if he had something for me, and he provided it to me, and I'll be all right.
You'll let me know if you're not feeling well?
I will let you know if I go, yes. I'm getting slowly, a little slowly better, yes.
Slow. You want me to just take a 15-minute
I'm
recess?
fine, I'm fine.
You sure?
I am, 100%.
All right, dear. All right. All right, stand up. Raise your right hand. You solemnly swear affirm testimony about this man the truth, the whole truth, nothing but the truth, so help you God.
I do.
You're still under oath, sir. Did you need your legal information?
I don't think so. No, I think I'm okay.
All right, well, let me know if you're not feeling well.
Yep.
You may proceed.
All right, and I'll try to be poignant in the questions.
Of course, I know you'll make that attempt.
Mr. Bashara, please state your name.
Pardon me?
Please state your name.
Robert Michael Bashara, Sr.
All right, and this is a continuation of your examination. You understand that, correct?
I do.
And this is our time to more or less explain some of the things that on cross-examination you weren't allowed to, or couldn't explain. Is that accurate?
That is accurate.
All right. Now, I want to, first off, with regard to Steve Tado, he is who?
He is a man that I was buying appliances from for anywhere from 15 to 20 years prior to 2012.
All right. And at some point in time, after your wife's murder, there was some information that you wanted to get from Mr. Tado?
It wasn't me. I was directed by Mr. Grimm, my then attorney, to go to Steve Tado and get a phone number and some information about his cousin. I was never able to procure it, and so I don't really know what the information was, but it was a phone number and some information about his cousin.
Whose cousin? Steve Tado?
Yes.
And did he have information pertaining to assuming?
I have no idea. Mr. Grimm, he had an investigator, and I was curious why he sent me, but at that point, I wanted to cooperate and help out as much as I could. So since I knew the man, I went to him and discussed getting this information.
Now, when talking with, and you eventually spoke in person with Mr. Tado, correct?
Several times.
All right. Now, when speaking with Tado, did the name Joseph Gentz come up?
He brought it up, yes.
He brought, and can you tell us how he brought it up?
Well, he was just saying how terrible it is that this guy murdered your wife. And I said, yes, it is very terrible. And I don't recall the specific conversations, but it was to do with him doing this violent act. Okay, and with regard, can you expound on that? What violent act are you?
Objection.
Sustained.
Relevance. Why is this relevant?
And Mr. Ambrose, and this is my concern, I wanted to give you an opportunity to do redirect. And my fear is that because there's another issue coming up, that you're trying to integrate that issue here. I'm not going to allow it, okay? I am going to limit, I've given both sides a lot of latitude. I almost feel like this has been a retrial, okay? But the point of the matter is that this is a motion for a new trial. And I believe that you're trying to make a record on issues that have not come in to play yet. Yes, there's been discussion about Joe Gentz, but my concern is, in light of this affidavit, you're building a record, and I'm not going to allow it, okay?
And if I could just state for the record.
You may, sir.
There was, on cross-examination, extensive testimony with regard to Steve Tado. Everything from his recorded conversations and the transcripts of those recorded conversations being placed before the court.
And may I? And the reason that they were is because there was a statement by your client that his confusion due to the death of his wife. That's why that was let in for that purpose. Now, we're not going to retry the case because that was the premise, okay? All right? And how do I know? Because I read 897 pages within the last week, okay? You may proceed.
Now, on cross-examination, I think you admitted to, or stated that you had actually paid Mr. Tado some money. Is that correct?
$2,000. Excuse me.
And did you want to go forward with? You had an agreement with Mr. Tado that $2,000 was for what?
Relevance. Why is
Sustained.
What was going to happen to the $2,000?
Sustained.
Did you ever admit to Mr. Tado that you had any involvement in the death of your wife?
Absolutely not.
All right, and
In fact, I told him quite the opposite.
I want to ask you about Bob Goddard.
Yes.
All right, there was some testimony with regard to Mr. Goddard. Did you ever ask Bob Goddard to rough up a tenant for you?
No, I did not.
All right. And you said it was taken out of context. What did you mean by that?
Well, Bob Goddard and I talked about my rentals all the time. He had a couple that he was managing for someone, and we were talking about the whole eviction process and collecting rent on judgments after we evicted someone. And I said, I'm looking for someone that can take over a lot of my judgments and do the collections. And I said, a lot of these people are very rough, and you're going to need someone that's tough enough to deal with some of these individuals that are not, that are less than decent people. They've moved into my places, they've trashed them, moved out in the middle of the night, or I've had to evict them where the deputy comes out and locks the door. So it's not been a real civil relationship with many of those people. I have probably 25 evictions.
Counsel, sustain.
Right. In essence, that you wanted somebody that could handle tenants.
That's correct.
All right. Not to rough them up and not to
harm them or hurt them, just to be tough enough to deal with that element of individual.
Okay.
That's correct.
Now, with regard to Tom Ramsey, you wanted him evicted?
Tom Ramsey was causing all sorts of trouble at my...
No, Judge.
We're not relitigating, I'm sorry. No, we're not. The basis of this is a new trial, ineffective assistance of counsel. There were some areas that you believe that he wanted some witnesses that were called. There was a motion, an improper motion filed by the defendant himself. We're going outside the scope, okay? And I'm not going to allow it. Let's move on, sir. Please.
And, yeah, fair enough.
Thank you.
And if I could just state for the record again, I mean, my questions are based upon my reading of the transcripts and some clarifications that I wanted, but I'll move on.
Thank you, sir.
There was some testimony with regard to you dropping off a check for Joseph Gentz after the death of your wife.
Yes.
Recall that?
I do.
What were the circumstances of you dropping off that check?
I think that was on a Thursday, the day after I was informed of my wife's death. I had...
And how much was the check for?
$452, as I recall.
All right, and what was it for?
That was for, 400 of it was for labor that he had provided. The total amount of labor was $800. $52 were for some supplies he had purchased I was reimbursing him for.
Okay.
I withheld $400 to pay for the utilities that I had put in my name back in October as a courtesy to him to help him out. He hadn't paid those bills, and in January I terminated the service. There was approximately $400 owed.
Narrative judge, and this is all he's doing is taking point by point. If somebody says something against him, thank you.
So you owed him some money?
I did.
Okay, and so where were you when you dropped off the check?
Objection, Your Honor. This started off with allegations in an affidavit. This started off as a motion for new trial. None of this relates to anything in his motion for new trial and in his affidavit.
There was, and I've cautioned you about that, Mr. Ambrose. Yes, there was discussion about Mr. Gentz, but the indication and how it was prefaced was the fact that, first of all, there was no threatening conduct initiated by Mr. Gentz toward the defendant prior to this, and then the only thing we really talked about were the phone calls and even how he came to know Mr. Gentz. Now, what it seems to me is that in light of this new affidavit, you're trying to put in this record information that may or may not come in based upon the supplemental motion. And I've cautioned you once, and I'm going to caution you again. But if you continue to do it, I'll just strike the testimony. Go ahead, sir.
And, Your Honor, and I have a client that I'm representing, and my questions are specifically based upon only the transcripts, from the transcripts.
Sir, but remember, the framework is that you wanted a new trial. There were certain things that you raised, okay? And there was latitude that I had given you, okay? Now you're veering off into other areas. This is just to determine if you get a new trial.
And I understand that, and I certainly...
And I've ruled, and I want you to go on.
And I do appreciate it.
Thank you, sir.
I mean,
Let's go on.
Okay.
Thank you.
On October 16th, and these questions are, and I should have made clear, my questions are just based upon the post-conviction transcripts of the cross-examination that I wanted some clarification on, and I could cite the dates
I
and
will
the
give you
page.
limited latitude, and I think that I've been more than kind and gracious to both sides, okay? But you may proceed.
All right. On October 19th, there was some testimony with regard to your attorneys, Ms. Diallo and Mr. McCarthy. Those were the attorneys that handled your trial, is that correct?
Yes.
And those were the attorneys that substituted in from previous attorneys, is that an accurate statement?
That's correct.
All right. Did you have any problems with the first set of attorneys?
Well, initially, no. I was happy with all three of them, Mr. Procida, Mr. Cooper, and Ms. Shell. But when Mr. Cooper began to fall off the case and then subsequently was removed, I don't know if it was by his boss or whom, I was very concerned, and I think as was Judge Evans. And so she ordered the replacement, and then Mr. Cripps was brought in. I was asked who I wanted. Actually, we hired Mr. Cripps, and then...
Objection, the narrative judge. If this is supposed to be question and answer.
All right. So you wanted Mr. Cripps at one point?
That's correct.
All right. And for whatever reason, I think at one point he was appointed for you?
Yes.
And then almost immediately removed?
Removed.
Do you know why? And that's a simple question. Do you know why?
I do not know why.
Okay. Now, when you were asked about, did you have any objection to Ms. Diallo and Mr. McCarthy did you know anything about them?
No, I did not. And the judge had espoused their legal prowess, and based on her recommendations and her glowing account of their legal history, I felt like I'd had good representation.
All right. Now, they were appointed, I think, was it March and April individually?
You know, I honestly don't recall. I thought it was more like January or February, and then April. I don't recall the specific dates.
Okay. With regard to the amount of, how much of the discovery were you provided?
Well, since I haven't seen everything of the discovery, I don't know what percentage, but I think, quite frankly, it was a very low percentage. I understand there were 100...
Objection, speculation.
Well,
He doesn't know, but I think it was low speculation.
You know, I'm allowed, go ahead.
What were you given?
well, I was shown 26 investigative subpoenas, and I was told there was 100 in the motion that they had filed. They said there was over 100 investigative subpoenas, and I was only shown 26. I still haven't seen the closing statements, the Skypes, the C of O, that I believe are absolutely false evidence.
And what you're referencing to is the closing statement for the Kensington property, is that correct?
Correct.
Okay, and the C of O is a certificate of occupancy for the Kensington property?
That's correct.
And was your prior testimony is that did you ever intend on closing on that property?
Absolutely not.
Have you ever obtained financing for that?
No, I had not.
There was some testimony as to you had made some police reports against certain individuals who, when you felt threatened.
Objection, Your Honor.
I'm gonna give them a little latitude. You talked about it.
Yes.
Go ahead.
All right. Now, that was it Jason?
Jason Popham?
Okay.
Yes.
Now, there was testimony also on cross-examination that you never called the police with regard to Joseph Gentz when he was calling you for money.
I didn't hear the question. So
They said you never called the police with regard to Joseph Gentz when he was calling you for money.
that's correct.
All right. Did you ever feel that he was as a threat as Jason Popham?
No, Joseph Gentz never threatened me. He kept calling me. We played phone tag for 4 months, and most of those phone calls never connected.
Did you ever feel that you had to contact the police with regard to his phone calls?
No, I did not feel that there was any threat or any aggravated, he just said he needed money for his daughter's custody hearing, and I told him I was only paying him $400, which was the testimony of Janet Lehman in the phone call.
Sustained.
On the morning of your wife's murder, you had made a phone call to Joseph Gentz early in the morning. Do you recall the phone call?
Which day are we talking
We're
about?
talking January 24th, 2012.
Okay,
Did you make a phone call to Joseph Gentz?
I might have, yes.
All right, but you have no independent recollection of what it was for?
It was probably returning his calls. I wanted to get a hold of him for 2 or 3 days prior to that to tell him not to come over, that I would drop the check off and get with him later in the week. I didn't have the money in the account, so I didn't want to give him the check until I knew the money was there, and I told him he'd have to wait. His hearing
Object to
wasn't...
the narrative, Judge.
Mr. Bashara, what you have to do is just...
I'm sorry,
You have to answer the questions yes or no and limited information when you explain it.
okay,
If it's not a yes or no answer, go ahead.
all right.
Go ahead.
I don't recall if I answered the question. You asked me why.
Yeah, why'd you make the phone call? And I guess what you were saying is that for a couple days prior, he had been calling you.
That's correct. And if you look at the phone records, out of those...
Answer the question.
Yes.
Don't indicate to the lawyer to look at the questions or do such and such. She's asking you to expound, okay? Thank you.
Okay.
You may proceed.
And he was calling you with regard to getting paid?
Judge, I'm sorry. What does this have to do with specifically the allegations in the affidavits and everything about the new trial. He never said in the new trial that there was any deficiency in the phone records and everything or anything like that. So why is when he called who?
And what I've indicated, Mr. Ambrose, because you're very skilled, is that this is your at least third or fourth attempt to bring into this record information, I believe, to substantiate the supplemental affidavit you've been filed in regard to Mr. Gintz. So I'm going to then ask you to stay away from that, and let's move on to the other issues. I know that was discussed, but at this point, I'm still bound by the motion for new trial.
All right, and with that ruling, I don't have any further cross-examination.
No, redirect.
Or redirect
Okay.
examination from the cross-examination, because, you know, I can pinpoint the areas where the cross-examination had and areas where, after reviewing the transcripts, I was attempting to get into.
Thank you so much.
All right.
Nope, you don't have any recross, do you?
No recross, Your Honor.
Thank you so much, Mr. Bashara. You can step down. Okay. What I want to do, and if my memory serves me correct, there were some ancillary issues that we needed to look at. Primarily, I do believe, wasn't there an issue where we had discussed and the court wanted to move on, but about an attorney that wasn't going to be proffered as an expert in the BDSM lifestyle at the very beginning of the hearing, and there was an issue about locating her. I need to resolve that because I want to move on to this other issue. What's going on with that? Is that still outstanding?
No, it's not, Your Honor. She will not get this.
Okay, beautiful. And were there some other requests, I believe, by defense counsel as to some issues that you wanted to go into other than what we presented thus far?
Yes, Your Honor. Back in October, I had filed a motion which involved some medical records that would substantiate my client's overall view of their marital relationship and the physical issues that they were.
Okay, and very good. At this time, the court believes, I'm not satisfied that there's sufficient basis by which to request them. I think that it was adequately covered in the examination about Ms. Bashira's limitations and her medical condition, and I'm satisfied that that's sufficient. Now, what else? So I'm going to deny that motion for medical records, and that will be given to you more materially. Next issue.
I filed a motion with regard to Joseph Gentz's, on Joseph Gentz's case. I believe the date of the, for whatever reason, I ordered transcripts on a certain date, for a certain date that was in the docket entries on our case. The court reporter said there was no transcript of that specific hearing. It was actually a hearing involving the case number for Joseph Gentz. So I filed.
For his plea?
It was.
Or was it post-conviction when he wanted to withdraw his plea then?
It was a post-conviction, but the date of his examination, or his hearing was October 10th, 2014.
Madam Clerk, can you see if Ms. Stenographer was here? Maybe she wasn't here, because I know that was on the record. I want to say, if memory serves me correctly, Ms. Reed was here with a number of other defense individuals, and I think there ultimately became an issue that he had appointed appellate counsel, Mr. Komorski, that was not notified, but that Ms. Reed was here in lieu of that. And I know that there was a copy of that hearing, but Madam Clerk will provide that with us shortly. Let's move on to the next area.
Yeah, and that it was on October 10th, 2014.
Yeah, that was Audrey
Audrey Cohen.
Conn.
Conn, C-O-N-N?
C-A-H-N.
C-A-H-N. Okay, so we'll have to get that. But I mean, how is that even relevant here? There's an indication in for your new trial that, you know, that you've laid out the fact that Mr. Gintz had filed a motion, well, had written a letter to the court, and the court had subsequently motioned it up about his desire to withdraw his guilty plea. How is that relevant to your client's case?
Well, and I just wanted the transcripts because on that day, I believe he mentioned that, I believe it was the date that he said that he was not going to testify. He wanted it as part of the record. It involves a confrontation issue that I wanted to pursue.
Well, I think that the people take judicial notice that that was the finding, that he did not want to go forward. Would you be willing to do that at this time?
Yes, he absolutely indicated he was not going to testify.
So we'll do an order forthwith, Madam Clerk, I have that available too, taking judicial notice that the defendant indicated that he would not testify in this particular matter, and that he was unavailable. So that's 2 orders that we will generate and have them ready for you forthwith. Next issue.
And the final thing I wanted to get into, it was with regard to my motion for discovery, but in particular, I spoke with the prosecutor this morning about some phone records that were alluded to during Ms. Lindsay's cross-examination of Mr. Bashara.
Okay.
And
was that regarding what the calls that he had made with Mr. Gintz, or the calls that he had made with Ms. Gillette?
No, it was phone calls that he had made on the afternoon of January 14th. Or
Okay.
I'm sorry, January 24th, 2012. She brought up phone records on, with regard to what his whereabouts. And it all, and I can specifically tell the court what I'm referring to. It's the November 13th, 2015 transcript. It's on page 11. And she had provided, or had a document, or some documents as to phone records of Robert Bashara on that day. I just don't have those.
Okay, were they the phone records that she alluded to when she was talking about Mr. Bashara and indicated that he did not want Mr. Gintz to bother him again, and he had called in excess of 20 times to indicate that, and then he called him on June at 6:24 a.m. on January 24th to say, "Don't bother me"? Are you alluding to that? Or the calls that he made subsequently, I believe, to Ms. Gillette? Not Ms. Gillette, what's the other witnesses where he says cease and desist all contact?
It was actually with regard to James Wagner and Pat Hawkins on that afternoon. He was downriver with these individuals.
Did you have phone records for that?
All phone records have been turned over to the counsel in discovery. He has all that. We've given him that in discovery. All the phone records with it's in the raw data that he was given with the cell phone records. It's not my job to go through his file and locate the information that was given to him. He has that.
I can't look. I mean, if I had it, Your Honor, I wouldn't ask for it. I mean, I can't find it. The information that they gave me, Your Honor, it's on a digital disc. On this digital disc, it's not indexed in any way whatsoever. I have to go through each and every file in this thing to try to locate certain documents. It's enormous, and I can't find it.
Mr. Muscat said all you have to do is press Control F. I mean, I'm sorry, Judge. He can consult with somebody to teach him how to go through the information. The only obligation that the people of the state of Michigan have to go through is to provide him with the discovery. Now he wants the additional thing of us to sit down at a table and spoon feed him.
And may I just say, Mr. Ambrose, you filed a 67-page motion for a new trial. I'm quite sure that the areas that you were able to cover, if that had been an area that you needed some guidance in, you would have put it in there, and you did not. The court And so therefore, I mean, this is one of the most extensive motions for new trial I've ever seen. And it's a very good one. But at the same time, I agree with Madam Prosecutor. Their responsibility is to give you the discovery. You have been capable enough to have gone through many transcripts in order to ferret out these issues. I want to believe that there were almost 300 witnesses. You were able to go through that. Moreover, the court even allowed you very extensive examination, some 847 pages, I want to say, of post-conviction testimony. Now, there's no more that can be done in this particular matter. I don't believe that the people have intentionally withheld any information. I agree. There was a lot of information. So based on the number of pages that you filed in this motion and during this examination, this post-conviction examination, you are more than capable of getting that information. So your request is denied. Next issue.
Can I just have a quick word?
Well, let's do this. Let's take a little 15-minute recess. You're looking a little bit better, and we're going to be able to give you some, I want to give you another sandwich, just get you going. And we're going to come back at approximately 11:15, and we're going to deal with another issue that may be before this court. And then the court will be able to determine what it's going to do with the remainder of the issues. What I am going to indicate is this, regardless of whatever we do with Mr. Gens, if that's an issue before this court. The court has read everything. I'm going to set a date for closing arguments, and then I'm ready to rule on this. I'm more than ready to rule on this area. All right, so let's take a 15-minute recess. We'll come back at 11:15 promptly, at which time we will be able to make a determination of how far we're going to go.